This week on Money in Your Pocket, David McGrady returns to educate us on the details of estate planning. We'll learn more about when to start the process and who to talk to about it. Estate planning is a process that ensures your wishes are met, your family is taken care of, and your assets go where you want them to. We've got a lot of information to cover this week, so let's get started.
This program is made possible in part by Credit Union One. Proud to support Money in Your Pocket. Credit Union One offers savings and lending options. Additional information on membership available at creditunion1.org. Loans subject to approval. Accounts are insured up to $250,000. By member's choice, this institution is not federally insured.
Thanks for joining us for another edition of Money in Your Pocket, and David McGrady joins me again this time to talk about estate planning. Dave, just give us a little background for people who maybe didn't catch you on our retirement show. Tell us a little bit about yourself.
Be glad to, Lori. I started my career at Pricewaterhouse, so I have a background as a CPA. And then after leaving Pricewaterhouse, came to Eastern, and I'm currently the director of the program financial planning concentration within the finance major here at Eastern. So our students sit for the certified financial planner exam after completing the program.
So you're training the future financial planners of America.
Some of them, yes.
Some of them. We're talking about estate planning. Let's talk about what all encompasses an estate. And it's not like when you think estate, you think of this grand palatial estate and the rolling hills of London or England. It's really not that.
Correct, yeah. What we're basically talking about is how are we going to transfer your assets after you're gone. So we need to develop a plan for that so that basically when you're gone, hopefully everybody gets what you wanted them to have when you wanted to have that. And really important part of this whole process, it's not necessarily about massive amounts of wealth, it's about maintaining family unity, that we don't end up in a situation where a sister isn't talking to a brother for the rest of her life because he got something that she really wanted, but that was never communicated during the estate planning process.
So just like retirement, I asked you this question, when should you start retirement planning? When should you start estate planning?
With estate planning, I think one of the key trigger points would be when you have kids, because that creates the issue, okay, if something happened to me and my spouse, what would I want to see for my kids? And there's a couple of issues there. Who's going to take care of the kids, who's going to be the guardian, and so you have to think through that issue. Hopefully communicate that issue not only to the person you've selected to be the guardian, but also to your children at some point. And that's a tough conversation to have, and this whole area is a little bit of a tough conversation, but if you think about it, it's something that if you don't address, probably nothing but bad things are going to happen possibly. Whereas if you do address it, you can maybe work through some issues and have a much more satisfactory solution. So I think at that point also too, you have to think about the idea, okay, if something did happen to me and my spouse and we've maybe start to accumulate a little bit of wealth, is that something I want to turn loose on my kids as soon as they hit the age of majority, which classically could happen if you haven't thought through this process. So, and that can have very bad results too, turning a kid loose with too much money at a very young age, yes.
So how do you you said early before we start taping that communication is a big part of this.
Yes.
Before you maybe get into the formalizing of the estate, what are some ways that people can start talking about the estate with their family and who should get what or what you would like to see happen? Right,
well, I think it's a conversation that needs to take place. Hopefully maybe there's a natural entree into the conversation that's it's not done under duress, that it's just something that could be as simple as, well, this situation happened to one of my friends at work where the individual that passed away didn't have a will, and now people are fighting over the assets, and somebody's already taken a bunch of the assets, and they have a big mess on their hands. And I really don't want to see that happen in our family, so let's talk about what we would like to see happen, beyond the time that I'm here.
So what are some things, though, that automatically happen? Say you pass away, your spouse, and you have a house. There are some things that just automatically happen, whether you have a will or an estate plan.
Correct. We have some things that pass outside the terms of your will. We have, for example, assets that are held jointly with the rights of survivorship. That asset is going to pass directly to the surviving person on that title, so we don't have to worry about that asset going through probate. So during your marriage, if you accumulate all your assets joint with rights of survivorship, there's no issue where those assets are going on the death of the spouse. And some people will make the mistake and say, well, why do I even need a will? Because of the fact I know that all these assets are just going to my spouse, and that's where I want them to go. Well, the problem is that doesn't leave a plan for the second to die spouse. At that point, then we've still got to find a home for those assets eventually. So that's why we have to think through that process. Other things that would pass outside the terms of the will would include things like retirement plans that are going to go to the beneficiaries that you've listed in the retirement plans. And that's something that we need to be very careful about, because a lot of times, you go to work when you're 25 and you fill out this 401k paperwork that you don't understand, and one of the things you're going to be asked to do is to list a beneficiary, and at that point perhaps you're not married yet, so you just pick someone randomly, a family member. Is that still going to want to be your desire 15, 20 years from now? Same thing with employer-provided life insurance. You're going to have that classically at work too. Well, that's another time where we have to designate a beneficiary. And with life insurance, it doesn't matter what your will says. The proceeds of that life insurance policy are going to go to that beneficiary you designated, as long as that beneficiary did not predecease you. So we have certain things that pass outside the probate process. So we think of the will as essentially the catch-all for everything else that doesn't pass automatically, and we need to find a home for it. Some people will set up what are called living trusts to avoid having assets go through probate. One of the really important things about if you do set up a living trust is you do have to remember to transfer title of the assets to the living trust. So the title of if you want to put your car in a living trust, no longer says Lori Casey, it says Lori Casey Living Trust. The same thing with brokerage accounts, real estate, whatever that you want to pass outside the probate process.
So where do you do the living trust at? Is that an attorney's office with your bank?
Yes, you certainly would have an attorney, and you would want an attorney that's well versed in estate planning to craft your living trust. And he's going to be drafting several other documents at the same time. He will also be drafting your will, he or she will, and then also probably more than likely things like health care power of attorneys that we might get into later on. But it's not, your will is not the entire estate plan. There are things that have to take place outside of that we have to think about.
So really
too.
The living trust is the big overall thing.
If you set one up and then transfer the bulk of your assets to that living trust, there may be very, very few assets, just your personal effects, that essentially pass under the terms of your will.
Okay, you've talked about probate a few times. Can you explain what that is?
Essentially, it's a court-supervised process where when I pass away, then somebody's going to have to determine where my assets are going to go. And we've talked about a lot of these assets might pass outside of probate, but for the remaining assets, then I'm going to, hopefully in my will, designated somebody that I want to be in charge of this process. And they will go to the courthouse and come with my will and basically say, here is what Mr. McGrady would like to see happen with his assets. And so this person that's in charge of this process then will make sure, first of all, that all my remaining bills get paid, if there's any transfer taxes that they get paid. And then after he's or she's accounted for all my assets and paid off my creditors, then start to think about the process of distributing assets to people that I've designated in my will. So it's essentially somebody stepping into my shoes, since I'm not here to do it, and saying, okay, here's how I'd like to have my assets distributed.
Now, I've heard that the probate process can get long and drawn out. Is that true?
It can be, but it doesn't have to be.
Okay.
Certainly in situations where you have unhappy family members, you can have people that can challenge the will, and so therefore it becomes a legal proceeding that can be very, very drawn out. But if you've communicated well and everybody's on the same page and most of your assets are passing outside of probate, it could be a fairly quick process. That's why, because of the potential though that it can be a lengthy process, we also have what are called payable on death accounts, which some people will set up on their checking account. And the reason for doing that is essentially there, all you have to do is show up with a death certificate, and the person they've designated then has access to those checking account funds. It doesn't have to travel through the courts to get to these individuals before they have the ability to pay, certain bills that I might want them to be able to take care of at that point.
I want to get back to the living trust. So say that someone watching, they want to do that. How do you start the process? What sort of things do you need to think about? Documents, paperwork, what do you all need to gather before you start that process?
Well, when you go to see an attorney, classically they're going to have a questionnaire for you to fill out, and they're going to ask you a ton of questions. And it's the same thought process that you think about, I think classically what people think about when crafting a will. Okay, if something happens to you, where do you want your assets to go to? Okay, well, let's say your spouse. Well, let's say your spouse predeceases you, then where do you want assets to go to? Well, okay, then in that situation, I want to go to my kids. Well, then they might ask you, well, how soon do you want them to go to your kids? Do you want to turn the dollars, the assets over to them immediately when you pass away? And you might sit and think to yourself, well, maybe not quite that quickly. Maybe I'd like to have you hold the assets in this trust for a certain period of time, maybe until the kids each reach age 30 or 35, or in my particular document, they get distributions 3 different times. They can take some when they're 30, some when they're 35, and some when they're 40, with exceptions if they want to buy a home. I believe they can take funds out for that. So you have all those kinds of opportunities inside a trust document to design a thing so it exactly matches what your desires are. Well, then they'll go even beyond that. Well, what if somehow you outlive all your kids? Then what do you want to have happen to your assets? Well, then you think about, okay, well, maybe I have nieces and nephews that would still be around. Well, what if they're gone? Well, then maybe I give it all to EIU. I don't know, WEIU.
Yeah, sure.
So you think about those types of questions in that process. And so that's what they're going to be asking you to think about prior to the time that you meet with them. And as you think about those questions, then certainly I think you need to draw whoever's going to be involved in receiving these assets into the conversation and tell them what your thought process is, because maybe they have some compelling reason where they feel like they would need access to the assets quicker than maybe what you thought about. And certainly we have can have the situations too where you're not leaving equal amounts to all your kids. Maybe you've helped out one of your kids more financially during your lifetime, and so therefore you feel maybe compelled to leave additional amounts to other kids. Certainly a situation that's challenging in this area is the issue with farmland, with the great appreciation that we've had in the value of farmland in recent years. And I come from a farm family, my parents came from a farm family, and certainly that's a very sensitive issue, is how do we keep this acreage together and maintain it for the individuals who would like to farm, but yet still quote unquote fairly treat the non-farm heirs.
Right.
And that's a challenging question.
And I think it would be the same thing if say you and your son ran a business together and the other children didn't.
Yes.
Well, what's fair and what's equal?
Right. And there's no perfect solution to that question, but the one thing you can do is sit down and talk about it. And in my family, we had a conversation about it, and I feel like we came up with a very good solution that my parents never would have drawn up if we hadn't talked through, I think this farm makes more sense for me and this farm makes more sense. And then we had to happen to have a couple of non-farm heirs, and we didn't really care about the sentimental farms. We just give us whatever was left over and we're fine with that.
And that's a much easier conversation to have whenever
ahead
of
time, yes.
Versus after someone's passed away and you have.
Yes, you're doing it all under the heat of the fire. If you can get the conversation started, this can hopefully go very smoothly, whereas when you're trying to do it on the fly under duress, it's not the same.
You talked a little bit about wills, and a lot of times we hear someone is the executor of the will. What does that mean?
That's what I referred to earlier as the person that steps into my shoes. It's essentially the person that I designate to carry out my wishes. So it can be an individual. You could also appoint the trust department at a bank to carry out those wishes too. So, and that's something that your attorney is going to also ask you about too, is who do you want this individual to be? And again, what if that individual either predeceases you or declines to want to serve? Then who's going to be the successor to that person? So lots of things to think through, but again, doing it ahead of time instead of just leaving it, if we have no estate planning done, if we have no documents done, then we die what's called intestate, where then it's basically the state has written rules that determine who's going to get our assets. And so if we're in a simple situation where, let's say, you're married but you don't have any kids, then the state basically says, well, the logical thing is for it to go to the spouse. But if you're married and you do have children, then the children are going to get an interest at the same time that the spouse does. And that may not be classically what you want, for a 4-year-old kid to have a half interest in everything at that point. And so that's why it's important just to think through these issues with the help of an attorney. And, it's obviously something you don't have to do, but I think if you value family unity down the road, and, it's not something you'd want to leave in a mess to your kids, that you just owe it to them to take the initiative and get the process started.
So in this electronic age where we have many a password for all sorts of accounts, what are some things that you can do to, if you're gone, people need to get access to your electronic life?
Right. The key in that area is to have what's called a side instruction letter, which whoever I pick to carry out my responsibilities, it would be great if I would also prepare a document for them saying, here's the things I think you would need to know if something happened to me. For example, here's who my attorney is, here's who you contact. They know what all my estate planning documents look like. Also, here's a copy of my past tax returns. This person's going to have to take, for everything that's going through probate, a listing of all my assets to the courthouse. So it would be nice if I would have some place where I list essentially everything, financially that I own, and also my liabilities, because he or she will be responsible for making sure those debts are paid properly. But then another thing that ties into what you talked about is the fact that with so many of these documents, my brokerage statements, checking account statements, all coming electronically these days, if I don't provide access to whoever this individual is to my passwords, they may have a much tougher time. And then there's certainly emotional things like Facebook accounts and things like that.
All the social media, those are things we don't think about.
Yes, exactly. And now I don't have a perfect, it's certainly if you list all that stuff, that's doing a wonderful thing. But when you're forced to change passwords every 6 months, it's really hard to remember to go back in and change that document. But if you give them a basic idea, if you have a universal password that you kind of use, that's certainly a helpful starting point.
What about when we get into power of attorney, and you told me there's healthcare and there's also property. What is the power of attorney? It
basically allows somebody to act on my behalf while I'm still alive. So if I'm in a situation where I'm non-responsive, and I've given you a healthcare power of attorney, then you have the ability to act on my behalf in terms of making medical decisions. Now, I might also, at the same time that the attorney prepared the healthcare power of attorney for me, they may have also prepared what's called a living will, which essentially directs you in terms of how I want decisions to be made. So, for example, do I want to be kept alive by artificial means to any extent possible? Well, I indicate that in this document. So it relieves, I think, some of the pressure off you when you're making very difficult decisions. If we've already had a conversation and I've said, Lori, I do not want to be kept alive, by artificial means And I want you to understand that, and I want you to not feel bad at all if that decision time comes, that you would be willing to make a decision on my behalf.
So if you don't have that, then it's just up to whoever is in the hospital room, the closest living relative, the spouse?
Yeah, then you can get into a situation like we had with the Shivo case where you can end up all the way even into courts because you may have conflicting opinions as to what should be done at that point. So that's the value of having these documents prepared ahead of time, that, you know, it's obviously not going to be an easy situation no matter what, but if you've made very clear your intentions and discussed those intentions, then it's much easier to carry out whatever your particular desire is. With the regular power of attorney, that just gives you power to act on my behalf in terms of if something happens to me and there's still bills to be paid, that you can essentially pay the bills or
write out checks.
Yes, exactly. And you can have what's called a general power of attorney, essentially allows you to do anything, or it can be restricted to just certain areas where you can act on my behalf.
Say you don't have any of this estate stuff planned and you suddenly do get sick and you need to do a quick power of attorney. How can you do that? Like, you're going to be hospitalized for a little while and you need to have someone sort of take over things.
Right.
Is it a quick thing that you can
Well, I mean, obviously you can go on places like LegalZoom.com and do some of this stuff yourself. I think because of the importance of this area that anytime you can get an attorney involved, I would get an attorney involved. You know, there's just so many things that obviously we didn't go to law school and they did, and so I think it's money well spent. Now, sometimes it's not easy, you know, if you call an attorney up today and say, I need to have this done 45 minutes from now, that may or may not happen, but certainly I think I would at least start in that direction.
So when you start this estate planning process, are you using, what is the difference between a financial planner and an estate planner?
Right.
What do you need to look for?
Well, with a financial planner, you know, they're basically going to want to see how does your estate plan fall into this whole process.
Okay.
So the responsibility is, have you addressed this area? You know, do you have a living trust? Do you have a will? Do you have the healthcare power of attorneys? But they're not going to be the person responsible for crafting those documents. They're going to have hopefully a working relationship with an attorney who will be preparing these documents that compose your estate plan, but they will be trying to make sure that the documents dovetail with your financial plan. For example, we talked about earlier, your beneficiary designations on your retirement accounts, that's technically part of your estate plan, but it's also part of your retirement plan too, that there are certain strategies that you can take advantage of. Let's say if your spouse predeceases you or you're not married and you want to leave retirement accounts to kids, well, there's certain strategic advantages to doing that. So that's why they should work with the attorney, but it's certainly not something where you would do it without an attorney, in my opinion.
Yeah, because it sounds like there's a lot of legal
language.
This
is very much law.
Law in the estate planning versus the certified financial.
Yeah, I mean, it doesn't, but you still got to remember the emotional side to it. And what you're looking at here is, do my intentions get fulfilled? And that's not really legal. That's more, am I keeping my family happy? And so it ties into what your overall financial goals are too. So certainly the two work hand in hand, but at some point you've got to have involvement of an attorney.
All right. Well, Dave, on that note, we're going to wrap it up. And thank you for coming by Money in Your Pocket again, giving us great information, this time on estate planning.
I enjoyed it. Thank you.
Thanks. The bottom line for estate planning starts with communication. Having the conversation with your family about your wishes is an important first step, ensuring that your wishes are met and your family is taken care of. Next, revise your plan at every major life event, such as marriage, divorce, birth of children, job and home changes, medical issues, and retirement. Each phase of life brings changes in your estate plans. And finally, estate planning can be very complex, so work with a qualified attorney who can help you navigate the process and prepare all the necessary legal documents. That's all the time we have for this edition of Money in Your Pocket. Have a great day, and we'll see you next time.
This program is made possible in part by Credit Union 1, Proud to support money in your pocket, Credit Union One offers savings and lending options. Additional information on membership available at creditunion1.org. Loans subject to approval. Accounts are insured up to $250,000. By member's choice, this institution is not federally insured.